It is in, ladies and gentlemen. Something I bet the judge had a really, really hard time writing. His entry of judgment. Let's read it. Welcome to the show. Yeah, here it is. In the Common Pleas Court of Adams County, Ohio, Sean Cooley et al. Versus Joseph Foreman et al. Jonathan P. Hein, judge by assignment. This matter came before the court on the 16th, 17th, and 18th day of March in the year of our Lord, 2026, for jury trial pursuant to notice on the following counts in the amended complaint filed May 10th, 2023. Count 3, invasion of privacy, false light publicity. And count 5, defamation. Prior to jury selection, plaintiffs dismissed count 4, invasion of privacy. So only 2 counts finally reached trial. There were 5 originally, but counts 1 and 2 was dismissed already in 2024. The plaintiffs were represented by Robert A. Klingler, Esquire, and Natalie Gretzler, Esquire. Defendant Joseph Foreman was represented by David S. Osborne, Jr., Esquire. Thereafter, the court and counsel examined the prospective jurors under oath until a panel of 8 jurors and 2 alternate jurors were selected. The court then administered the oath to the jurors. Counsel for both parties made opening statements. Plaintiffs then presented their case through 10 witnesses. Numerous exhibits were admitted. Yeah. all the videos. all the videos. Plaintiffs rested their case. The defense motion for directed verdict was overruled, which for some screwed up reason explained to the jury. And I've never seen that before. I have never seen that before. That is, directed verdict is, in every other trial I've seen, it is outside the jury. Outside of the presence of the jury. Defendant presented his case through 1 witness and several exhibits. Rebuttal testimony was not offered by the plaintiffs. Yeah. Mr. Klingler and Mr. Osborne made closing arguments. The court then instructed and charged the jury. The alternate jurors were excused. The jury retired to deliberate their verdict. After approximately 6.5 hours of deliberations, twice the time of for this is a normal time to deliberate, in my opinion. 6.5 hours, 3-day trial. That shows me they really took their job seriously. For a 3-week jury to be out just a couple of hours, for me, it doesn't ring well. And if they had been out deliberating for 2 days because of this, it's a First Amendment case. You should take that seriously. But 6.5 hours is, yeah. The jury returned written and signed general verdict forms. On all claims against the defendant, the jury found in favor of defendant Foreman. The jury was then discharged. Based on the verdicts, injunctive relief, as requested in count 6, cannot be granted since such relief is not a separate cause of action. Therefore, this count must be dismissed. It is therefore ordered and decreed that judgment is entered on behalf of the defendant. This matter is dismissed. based upon the relative merits of the case and the justiciability of the claims. Costs are divided 1/2 to plaintiffs and 1/2 to defendant foreman. Yeah, they bear their own costs, it seems. Final appealable order by Jonathan P. Hein, judge. Now, first of all, it's amazing. Afroman won. Does this mean the final word is said in this? No, because all of it are appealable from both sides. It's a civil case. Both sides can choose to appeal. Will Afroman appeal? No. He's fine. I would be very, very surprised. Now, he could, for his countersuit, yeah, sure, he could. I don't see a specific reason to why, since he won. Had he lost, yeah, go right ahead. Now, for the plaintiffs, can they? Yeah, sure they can. They can appeal this, all of it. Should they? No, not in my opinion. In my opinion, they might have realized by now what an extremely bad idea this was. And the second reason is, can they afford it? Because Mr. Klingler might have worked on a retainer or contingent. I mean, if we win, you pay me kind of deal. But for appeal, yeah, now they have to pay. I would be surprised if an attorney took an appeal on nothing but a flat rate. I still think that would be a bad idea. Now, the only one that I could see is the case against Lickham Low Lisa. Because according to information, only 6 out of 8 dismissed her case. And I do believe her case was damaged by having all the others in it. So, but then again, does she want to, and should she? And I honestly do not think that she should. But I will continue to have I will have an eye out to see what happens. And if something happens, I will tell you guys. Thank you for listening in. You all have a good one. And with some pound cake. See you in the next stream or video. Bye-bye.